Good morning, everybody, and welcome to the Bristows Rapid Reaction webinar to the Supreme Court's groundbreaking judgment in the Unwired Planet and Conversant appeals. Just to introduce who we'll be talking to this morning, my name is Pat Treacy. I'm the head of competition law here at Bristows, and I'll be joined today by our joint heads of patent litigation, Andy Bowler and Myles Jelf. We've both done a lot of FRAND and SEP work over the years, as have a number of our colleagues. So we've been waiting for this judgment with bated breath. I should say that Bristows was involved in the cases that led up to this Supreme Court judgment, and that anything we say in the course of this rapid reaction shouldn't be taken as either representing the views of the firm, and certainly not as representing the views of any of our clients. So over the next coming days and weeks, there will be more material about this case on our website and doubtless elsewhere. But for this morning, we really just wanted to give you our quick take on what the real takeaways were from this judgment. I mentioned in my first couple of sentences that the judgment was long awaited, and indeed it has been. It's also very important in the sense that it's the first time that the Supreme Court of any jurisdiction has had the opportunity to reach a view on the concluded terms of a FRAND global portfolio license in any jurisdiction in the world. We'll never know what the reason was for the length of the time between the hearing and the judgment, but I think when you see the judgment, you'll agree that the Supreme Court has used that time wisely and well. The judgment is long, it's very thorough in its approach to the underlying policy, and indeed it's unanimous. So the justices have clearly taken some time to discuss the issues and really come to a firm and concluded view on how the particular issues in this case have actually been resolved. Now, as many of you will know, and I'm not going to go through the long and convoluted procedural history, the principal issue, which was before the court, was whether or not an English court had the ability to, and was entitled to, set the terms of a global portfolio FRAND license for SEPs. Particularly in a situation where the parties had not agreed that it should do that. The court dealt with 5 specific questions, and we'll deal with each of those in turn. But just to get to the outcome, before we go to the detail, just to let you know that the Supreme Court upheld the judgments below in every particular, and indeed was very complimentary about the judgments below. It has amplified some of the policy considerations. It has looked at some of the reasoning in more detail, but it's a very strong endorsement of the approach of the lower courts. And really, if you want one single takeaway, it's if you were already following the rules set out by the Court of Appeal, then nothing needs to change. The Court of Appeal decision has been endorsed in every respect. Just before we go to the detail, I think just stepping back and taking a very high-level overview of the court judgment, it has very strong policy underpinnings. The Supreme Court explicitly recognizes the tensions inherent in a system of national patent enforcement and a global telecommunications market, which is based on standards. So they explicitly recognize that. And then they try and resolve some of the resulting difficulties. They base their judgment on the overarching view that FRAND disputes are commercial problems that require someone to be willing to provide a resolution when the parties cannot. And the Supreme Court recognizes that no overarching forum has been chosen by the parties to the ETSI IPR policy as to where those disputes should be dealt with. And in those circumstances, the court takes the view that it is the job of national courts to do that, and that the English court is both well placed and very willing to resolve those disputes. And I think, finally, the court really says these are commercial problems, and it's important to have regard to commercial practice and commercial reality in deciding what the correct legal response is to the issues that arise. So that is really the 10,000-foot overview of what the court decided. And now to get a little bit more into the detail of what the court decided, we're going to look at the first question, and perhaps the most important question that arose in the context of this overall dispute, and that is whether or not English courts have the jurisdiction to determine the global terms on which a portfolio should be licensed by a patentee to an implementer. And Myles is going to take the lead in that particular part of the discussion. So we're just turning now to the first main question.
So the first aspect of this is the question, can the English court set the terms of a global multinational fran license? And I think it's important to bear in mind that this discussion is not one of whether the court should be doing that, but whether it can do that. So a discussion that the court phrased in terms of justiciability. So what is there something here that the English court or indeed any national court is actually entitled to determine? The appellant's viewpoint throughout the proceedings was that what is happening here is a global declaration. That's the center piece of this of the case that's been brought in both cases, was a global declaration that certain license terms should be applied to resolve a global dispute. And what the appellants were arguing is that if one court makes that declaration on a worldwide basis, then there are a number of legal rights that end up being compromised. And those legal rights on the part of the implementer include the right to challenge the validity of the patents being licensed. Similarly, the right to challenge whether or not the patents that are said to be in the portfolio are actually infringed or are actually essential. The argument goes, given that it's accepted that at the very least validity should be reserved to the court of the country that issued the patent in question, if you impose license terms that mean somebody effectively has to pay for that foreign license, it is presupposing issues of validity, and it is removing from the defendant the utility and in so effectively the right of challenging that validity. Therefore, it's an overstepping of the mark by any national court. What the Supreme Court's response, again, as Pat indicated, in line with the way the Court of Appeal viewed things, was that fundamentally all this is a question of relief flowing from national patent infringement. And they start from the principle that a patentee is entitled to bring proceedings where it chooses. And if they argue, if it's right that you were required to determine the fran question in each different country, then if the fran question is linked to the patent prosecution or the patent litigation, then by forcing fran in every country, you're forcing patent litigation in every country. And their starting place is it's really for the patentee to decide where it should bring its proceedings. The way their analysis flows is that if the patent that's brought is a standard essential patent, then that means there are probably FRAND obligations in play that arise from a contract. And the judgment, probably in contrast to the Court of Appeal perhaps, places great weight upon the fact that the ETSI IPR policy, the ETSI obligations are a contract. And the way the court sees it is once there is patent litigation on foot, it's the defendant who then chooses to rely, by way of defense, upon rights arising out of that contract. And one way of, in shorthand terms, viewing what the Supreme Court has done is to say, if a defendant wants to rely on that contract, it can't then object to the court which it's before determining whether that contractual defense is made good. And in shorthand terms, that is the way they perhaps skip to the answer that the court does have the right to decide these questions. In fact, they go beyond there and they say that once the patent action is in play before the national court, the English courts in this case, and presumably other courts in similar cases, have no choice but to exercise jurisdiction. We'll open the discussion up shortly to some of the wider issues, but one immediate observation that flows from that is, reading this decision, it appears as if the UK has very much fired the starting gun for global FRAND determinations, as the logic of its jurisdictional viewpoint would certainly seem to apply to other courts, certainly where the patentee holds national patents that can be litigated, that have a FRAND obligation attached to them, and possibly more widely still in respect of declaratory relief, in respect of that contractual obligation that the Supreme Court relies upon so much. And that second aspect could open up some interesting discussions about what forums are open to implementers who want clarity about the scope of what that contract obligation is. So having given the headline there, I'll perhaps hand over to Pat for an allied aspect here. Having said the UK court can have jurisdiction on this point, how, in exercising that jurisdiction, how much account can the courts take, and should the court take, of proceedings and judgments arising from other territories?
So the question really is the extent to which the court will take into consideration FRAND or SEP proceedings that are going on elsewhere. And the court's answer, in some ways, in accordance with its overall approach, is based on policy, but unfortunately it's also based on reality. And the court says that the extent to which, or the way in which, results on foreign patents or in foreign FRAND proceedings will be taken into consideration will depend on the circumstances. And from a policy perspective, and this is something that flows throughout the judgment, the emphasis is on the responsibility of the parties to negotiate. And the court places responsibility on both parties to negotiate, and indicates that the court will try and replicate real world conduct where it can, as far as possible. So how does the court do that? Well, first of all, it explains that the FRAND obligation in the ETSI IPR policy extends to the fairness of the process that the parties engage in during the negotiation. The court notes the burden on the parties of having to litigate around the world, as Myles has already said, and makes it very clear that it is not acceptable for parties to delay concluding a license until all the possible uncertainties have been resolved, and particularly uncertainties around validity and infringement. So it's quite clear about that. It's also very clear that it may be fair and reasonable as part of the process for the implementer to include in its FRAND offer a mechanism for taking into consideration changes in what the parties know. So in other words, if an implementer is aware that there are particularly important patents or groups of patents which will significantly affect the royalty it might have to pay in a particular jurisdiction, it would be perfectly proper for the implementer to seek to include a mechanism in its license for that to be done. But, and the court is also very clear about this, I think, the implementer must be reasonable. It's part of this FRAND process that the reservations that the implementer seeks to put in place should be reasonable. And if they're too great or too overwhelming to allow a really proper and easy resolution of a FRAND dispute, perhaps easy is the wrong word, but a fair resolution of the FRAND dispute, then that is inconsistent with the public policy underpinnings of the whole FRAND regime. So reservations and adjustments need to be reasonable. But I think the quid pro quo of that is that the patentee's reaction to those reservations and adjustments should also be reasonable. So this is part of the Supreme Court's analysis of FRAND as being about reasonableness and proportionality and commerciality in the way in which the parties react to the FRAND obligation. And I think once you come to read the judgment in detail, for those of you who are particularly interested in this issue, paragraphs 61 to 64 of the Supreme Court judgment are really particularly interesting, and they show how the Supreme Court understands the FRAND process to work. Now, those of you who have been in the industry for many years may well say, well, the Supreme Court is quite idealistic, or the Supreme Court has not really had the opportunity of seeing evidence of how many FRAND negotiations do work. But nevertheless, from its policy perspective, the Supreme Court is pretty clear. And it says we need to deal with the unavoidable uncertainty of the regime that exists. Practically, the Supreme Court says implementers need a license to access the market without undue risk. And by taking a license, implementers buy access to that global standard. The court's quite clear that the price of doing so, in that sort of, not quite preemptive, but in that insurance sense, ought to reflect the fact that many patents in any global portfolio will be completely untested. So there should be a sort of uncertainty adjustment in the price of any portfolio license. The court also says, and this is very interesting, that IP owners are entitled to be paid for their technology, even if the patents that form their portfolio have not yet been tested and upheld. So a very interesting statement by a Supreme Court. But go on to say, as I've already mentioned, but adjustments ought to be possible as more information becomes known to the parties, and seeking those adjustments by either party, the way in which they deal with that, should be reasonable. There is no prohibition on seeking injunctive relief if infringement and validity are established. But the Supreme Court is very clear that the court has a real role in setting the terms of a license, which may avoid injunction, and that may be global and portfolio-based, having regard to all the evidence. And probably the paragraph of the judgment which encapsulates all of that is paragraph 86. So quite an interesting approach by the court. Very clear that foreign judgments, foreign actions can be taken into consideration, both by the parties and by the court. But the way in which that will happen will very much depend on all the circumstances. So having looked at that overall approach by the Supreme Court, I mean, it's very clear there are lots of discussion points which are going to take up a lot of time and attention, both for lawyers and for licensing executives and for commercial undertakings for many, many years to come. But I think one of those is a point that you, Andy, felt particularly strongly about, and that is how that will apply where there isn't a handy contract that you can actually attach your FRAND obligation to.
Yeah, okay, thanks, Pat. Let me pick up on that point then. So clearly the basis, as Myles has said, for the court's jurisdiction to consider FRAND terms for a portfolio which includes foreign patents is this contract or undertaking, which in this particular case was in the form of the ETSI IPR policy, which the court said can be enforced by implementers to vary the patentee's usual entitlement in a normal patent situation to injunctive relief. And the court basically held that its jurisdiction, it has jurisdiction to enforce that contract and determine the terms of a license that remain in dispute. So that was the basis of the jurisdiction argument. But the court interestingly expressly said that in the absence of such a contract or undertaking, it could not determine a license covering foreign patents. So fine for ETSI, for example, but the jurisdiction does not seem to cover patents declared to SSOs, which don't have one of these contracts or obligations to license in place. Or which we sometimes see perhaps patents which are essential to some sort of de facto or informal standard that would appear to be outside the court's jurisdiction. So I thought that was a sort of fairly interesting point, which the court makes expressly.
Thanks, Andy. That's an interesting point, and we will have to see if there are other fertile and innovative ways that people can get around that particular issue. But I think, Myles, you had a view on that, and also I think on one or two other things around the injunctive relief point in particular.
Yeah, absolutely. I'm picking up on what Andy said there. One thing that comes to me much more strongly out of this judgment than we saw in the earlier judgments is this great emphasis on the contractual nature of the court's right to rule in this case. And the court goes to great lengths it runs through all the cases it was presented with in other jurisdictions in the US, in Germany, Japan, China, other cases, and tries to draw this thread that says, well, what we're doing is entirely consistent with all those cases because it's all about ruling on a contract. And they, having done that, they then make this case quite specific about this particular contract arising from the ETSI IPR policy, and they say that needs to be seen in the context of its particular nature. And they talk about what the policy objectives were they can see underlying the IPR policy, and they even talk about some of the toings and froings in its creation as being supportive of their fundamental position. So it's all very focused on this particular contract. One thing they say, though, flying from that, is it was put to them, if you're right that the English court has this jurisdiction to rule about something that's going to affect everybody everywhere, surely the logic will apply to other courts as well. And therefore, if we go down this road, we're going to have just a huge free-for-all with jurisdiction grabbing, with preemptive actions, with anti-suit actions, trying to pull actions back into other jurisdictions. And the court basically says, yes, absolutely, that is likely to happen, and it arises because of the nature of this contract. The parties to the contract, the ETSI IPR, those who formed it and those who are part of that system, could, if they wanted to, have put in an arbitration clause or put in a governing law and jurisdiction clause, but they didn't have those jurisdictional arbitration provisions in mind for one reason or another. One suspects largely because that would prove quite difficult to agree. But because that's not there, the court quite openly says there is going to be a lot of jurisdictional issues arising from that, because here we have a contract and nobody has said who or where it should be adjudicated.
So thank you, Myles. I think that was a really interesting issue. So we now know that the English court can take jurisdiction over these global disputes. But I think perhaps the next question the court asked itself was, well, in this particular case, should the English court take jurisdiction over the dispute? And I think Andy had some thoughts on that one. Thanks, Andy.
So thanks, Pat. So this is a separate legal issue to the question of justicability, which we've just looked at, which is whether the English or a foreign court can do this. And this is all about whether the English court is the convenient forum to hear the dispute. And this is a point of English law which only really arose in the Conversant case and not in the Unwired Planet case. And the court agreed with the lower courts that the answer in this case is that yes, England, rather than a foreign court, is the convenient forum to hear this dispute. So I think it's fair to say that the discussion very much focused on the particular case in hand. And effectively, the starting point was the court agreed with the implementers, so ZTE and Huawei, that the correct question to ask is which court is best placed to deal with the fundamental dispute between the parties, rather than how has this case been specifically pleaded in the English court. So which court's best placed to look at the dispute overall? And the question there really is, well, is the fundamental dispute between the parties what are global fran terms? With the kind of UK patent infringement issues simply a kind of hook to get the action before the English court? Or really, is this a question about what's the appropriate relief for UK patent infringement, which is what Conversant was arguing? And the court preferred this latter formulation, which of course ties the case firmly to the UK as its focus is UK patent infringement. But the court overall decided that it didn't need to answer that question because even on the implementer's case, there needed to be another jurisdiction in play to determine the global FRAN terms. And only China was put forward by the implementers, and the courts below had determined on evidence, including expert evidence from Chinese lawyers, that China at present, and I kind of emphasize at present, because I think this is a moving feast, does not have the jurisdiction to determine the terms of a global FRAN license. The implementers have made a formal offer to Conversant to have the global FRAN dispute determined in China with the agreement of the parties. But first of all, Conversant rejected that proposal and the courts below said that was reasonable. But in any event, there was a finding that it was still only speculative as to whether the Chinese court would entertain a global FRAN determination, even with the agreement of both parties. So taking all that into account, the English court had to be the convenient forum because the court had already decided that it could look at a global FRAN license. I think, interestingly, of course, this does even leave open a lot of open questions as to what will happen as and when other courts of other jurisdictions start determining global FRAN licenses themselves in competition with each other, which one suspects is probably a natural reaction to the judgment of the UK Supreme Court. Myles or Pat, do you have anything you'd like to add on this forum convenience point?
Yes, I think the whole jurisdiction issue, that sort of jurisdiction issue on forum convenience points is going to be an area where there will be a lot of ink spilt over the next years, not only in global terms, but also in the context of the Brussels regulation and whatever regime follows the Brussels regulation. So I think there are a number of issues which are not resolved by this, but the court didn't have to resolve them. And I think they probably took the view the judgment was sufficiently long already without going obiter on any of those issues.
Yeah, I agree. I mean, I think, you know, as I said, the court's sort of initial reaction was if there's a patent infringement case, then that may resolve the issue anyway. But I think what could be very interesting is if an implementer starts, if it's possible to do so, a standalone action for a FRAN determination, then you have the issue of which competing court, assuming other courts agree that they can do so, is the right one to hear that issue. And that could be certainly a point that could arise in the future.
Yeah, absolutely, particularly because of the sort of focus on the contracts. You know, to me, that gives all interested parties now can say, well, look, here is a dispute that I want a declaration about that can be ruled on that is justiciable. And, you know, both communities might have an interest in having a declaration to that effect.
Well, I think as I said, the jurisdiction issue is clearly one which will run and run. Something that has run and run for quite a long time is the question of non-discrimination in FRAN and how the English courts interpret the ND bit of FRAN, or indeed whether there is an ND bit of FRAN, or FRAN is just a single concept. And in this regard, the Supreme Court, I think, as with most of the judgment, agreed with the lower courts on the substance. So the Supreme Court held very clearly that when it comes to non-discrimination in the context of the FRAND-ETSI contract, that is a different beast from non-discrimination as competition lawyers might perhaps understand it. And certainly what it does not equate to is a most favored nation clause. And the court came to that through a variety of routes, one of which was looking at the nature of FRAN itself and how it's made up, whether it's three different bits. And I know, Myles, you were particularly taken by the Supreme Court's approach to FRAN as a thing.
Absolutely. I love the discussion where they To be fair, is a discussion I think a number of us have had previously. Is what is the difference between fair and reasonable and not? What do they all? Once something's fair, what does the rest add? And they come up with this sort of holistic view where basically you can't read them as separate entities. There isn't a fair requirement plus a reasonable requirement plus a non-discriminatory requirement. The whole thing is taken in the round. The three all mean the same thing, and they base themselves very much again on the contract, on the intention of the contract, which was just to give, to avoid hold up, but to make sure that innovators had a fair return. And so really they take the fran, they'd say a strict linguistic analysis is not what was contemplated, it's just what was fair. And in that respect, the non-discriminatory aspect is just another way of viewing was this fair or not. And what's fair is that there's an objectively justifiable rate available to everybody. And that's as far as they think the fran requirement goes under that ETSI contract.
Yeah, and they gave a sort of practical example in the case as to why the ND limit fran shouldn't be treated as a sort of freestanding obligation which can trump the other bits of the obligation. And that was this earlier license that had been given by Unwired to Samsung that were at rates less than the value of the portfolio. So not fair and reasonable to use the other bits of the obligation. And the Supreme Court said, well, to require Unwired with that factual background to license at those rates that have been given to Samsung, which was in a particular commercial situation, would give the ND bit of the fran obligation an extreme effect because it would effectively trump the fair and reasonable bit. And the court had already said that the Samsung license was not really equating to fair and reasonable. So they gave a practical example there as to why this sort of holistic approach was the way forward.
I think one of the interesting things about the Supreme Court judgment on this issue, as with quite a few other issues, was again the commercial pragmatism the court brought to it. I mean, the court was very clear that in its view, differential pricing is part of normal commercial licensing practice, and that it would be both economically irrational and potentially very harmful if differential pricing were not to be permitted. And they went back, and this is another thing that really flows through the judgment. They looked at the ETSI IPR policy, and they actually looked at some of the history of the IPR policy, as Myles mentions, to try and work out whether there was any indication that when ETSI said non-discriminatory, they really meant hard-edged, absolute, no differentiation. And using the negotiation history of the ETSI IPR policy, plus this approach that commercial pragmatism would mean that you wouldn't import that without being very clear that that was what you intended. And the court used that to support the conclusion that in the context of the ETSI IPR policy, at least, the ND bit of fran means you need to give everyone a reasonable and fair license rate, which will enable them to access the market. You don't need to give everyone the same price. So a very interesting approach by the court to this particular issue, I think.
And one as well, I think that probably, parties will find themselves in different situations. But this, for me, this is an aspect that could be sensible for people on all sides of the debate, because if you're somebody looking for a license, then you don't want to be in a position where the license you want to buy could actually be offered to you at a discounted price effectively, but the licensor says, I'd love to do that deal, but I just can't, because then that causes me problems down the line. So it gives greater commercial freedom for those practical negotiations, I think, to all potential participants in the overall structure.
Yeah, I think one thing that will clearly come out in the future, though, is that this sort of thing is fine for players who are sort of similarly situated in the telecoms industry. But what happens when you start getting into the world of IoT and that kind of thing, where you have different kind of units which use connectivity to a greater or lesser extent, That's certainly a point to look out for in the future, I think.
So I think another point which is of general interest to lots of people is how the Supreme Court dealt with the view of the Court of Justice in the Huawei ZTE case about the dance that it saw as between implementers and patentees. And it will come as no surprise by this stage to hear that the Supreme Court agreed essentially with both Mr. Justice Burse, who they went out of their way to praise, and also with the Court of Appeal on this issue. The Supreme Court was very clear that if you seek an injunction without prior notice of some sort to the implementer, then that is an infringement of Article 102. So they were very clear about that. As to the rest, the court essentially said that the Court of Justice in Huawei and ZTE was very careful to put its judgment in the context both of the facts and of commercial practice, and that the Supreme Court was following that by doing pretty much the same thing. So all of the other aspects of the Huawei ZTE dance, the Supreme Court said it will depend on the circumstances, how much impact those have on whether or not an injunction should be granted or not, and whether or not a patentee, by seeking to have an injunction, is actually infringing Article 102. Perhaps one of the more interesting things about what the court said is that even on the notice issue, that will also depend on the facts, that there's no one size fits all in terms of what sort of notice you have to give or when you have to give it. And I don't know, Myles and Andy, given your experience with looking at litigation both in this jurisdiction and elsewhere, how you think that will play in litigation really around the world.
I mean, I think one sort of interesting thing is obviously there may be a difference between sort of larger implementers with sort of big IP departments and smaller implementers, and I go back to my earlier point on the Internet of Things. But a separate question may well be that greater information in terms of claim charts and things may well be required, perhaps for a first license as compared to the renewal of a license, which again needs to be negotiated. But by that stage, you'd have thought perhaps there's an argument that the implementer has had fair notice that it needs a license. So there may be a difference between those two scenarios, and between different players, perhaps between the Internet of Things and perhaps more established players in licensed technologies like mobile phones.
I completely agree with that, and I thought, I mean, for me, there were two things that came out of this aspect of the case. Firstly, again, they go back to the contract, they go back to the context of this, and they saying the point that they see the CJEU was trying to make is that there shouldn't be an ambush. The implementer shouldn't be bundled into litigation before they've had the chance, as contemplated by that contractual background, to arrange a license, to buy the insurance policy, as Pat was talking earlier on. So that the notice is to prevent that ambush, that bundling over, is the first point. And the second point, in addition to, Andy says, different players will be different contexts, maybe there are different notice provisions, but also different systems. If the enforcement action you're contemplating, there are different systems in different jurisdictions, and they expressly kind of name check the fact that the considerations may be different. If you've got a system that would allow, say, a preliminary injunction, that might be different to a system that doesn't allow that, and in fact no injunction is going to issue until you've looked at all the issues, including infringement and validity and everything. The notice provisions may be different because of that following system.
I think that's very fair. I think the court was very alive to the fact that this case had come out of the particular way in which English litigation works, and the way in which injunctions don't issue until really well after all of the key issues in the case have been resolved. And I think that was very clear. One other interesting thing I thought about the court's approach, and it really does reflect the policy impetus that underlies all of it, was that they actually name-checked the European Commission once or twice, and in particular in this context, talking about the Commission's view in its SEP communication from November 2017, and how the Commission looked at the Court of Justice's rules. So I thought that was interesting. And I think for those of you who want to rush immediately to find the key passage, you'll find the court's overall take on this notice issue about paragraph 157, where they really do make very clear that it's all about balance. It's about recognizing the need for access, but also the need for patentees to be able to enforce their IP rights and ultimately get a fair reward. So very interesting, again, by the court, trying to look at everything in the round.
I think for me, the last sort of key point that they stress was, because it's interesting thinking about this in the notice context, they say, looking at the Huawei Unwired case in particular, paraphrasing them, they say, well, at the end of the day, Unwired were prepared to license on whatever terms the court said were going to be fair, and Huawei took a more restrictive view and said, well, we're only really prepared to take a license on what we understand to be fair and reasonable. And almost that debate took the place of the notice debate in some ways, that if you go to the court and say, well, look, all I'm asking for is whatever you say is fair, that in itself is going to mean that the notice issues are going to be less pronounced for you.
Thank you. I think that probably brings us to the final question the court asked itself, and this may be perhaps of less interest to our international listeners and of more interest to those who are looking at the practice of the English courts in awarding injunctive relief. But I think the final question the court asked itself was, well, assuming that granting an injunction is acceptable, or let me put it a different way, because the court can always do what it likes, but assuming it was all right for Unwired Planet and Conversant to ask for injunctive relief in these circumstances, were there any equitable reasons why the English court should or should not have granted that injunction? So was there any equitable consideration the court should have taken into account?
Yeah.
So, I mean, Andy, I have a view about this as well, but for me, this is a kind of a replaying of the same discussion you had in the eBay case in the US. And in fact, the court name checks that decision and goes through the logic behind it. As to, given that we're all agreed, the purpose of this whole exercise, the purpose of the SEP exercise is to make sure that the innovator is fairly rewarded, and that's always going to be about money. This is always going to be a money dispute. Is it, in those circumstances, isn't it disproportionate to be taking people off the market? I think that's a way of phrasing the question they were asking. Now, Andy, I don't know if you'd agree with that.
Yeah, no, I agree with that. And then, but I think the conclusion they reached was that to suitably incentivize the implementer to take the fran license, injunctive relief needed to remain on the table, because if it was only a question of damages, and in this case, I think they were assuming national damages based on UK sales, that would not suitably incentivize the implementer to take the fran license and could lead to holdout, whereby national litigation needs to start in many countries in order to get financial compensation for the patentee. So the court very much looked at this issue again, as it has previously, in relation to this balance under the ETSI IPR policy between the implementer and the patentee, and thought that really injunctive relief needs to remain on the table when the implementer has declined to take the fran license.
I mean, I think it's very interesting, the point you make about damages, and to some extent, the Supreme Court looks both ways on damages. There is a throwaway comment a little bit earlier in the judgment, and I'm not sure it is really throwaway, because I'm not sure to what extent the Supreme Court does throwaway comments. But there is a comment earlier in the judgment, I can't remember quite where, which seems to suggest that a fran license might be a good starting point for a damages calculation, and they go no further than that. So they don't really say what sort of fran license. But one of the issues that we may have to grapple with in the future is what precisely that means, and whether, even though the legal activity the court's undertaking in thinking about past damages as opposed to a future license may be different in a sort of ideological construct, whether the court may be suggesting that perhaps the outcome might not be a million miles away. I mean, that would be quite a major move, I think. And probably it's not what the court had at the front of its mind, because the discussion it then had about injunctive relief sort of moved away from that. But it is interesting that they dealt with damages slightly differently, potentially, in two different parts of the judgment.
Yeah, I agree. Yeah.
So I think overall you'll have gathered from what we've said this morning that even on a pretty quick review, there's quite a lot in this judgment. The Supreme Court has taken a lot of time and trouble to look at the whole thing in its context. As you would expect, they recognize that this was an important issue, sufficiently important to bring it to the Supreme Court, where there's no right of appeal. They have to take it because it's a matter of public interest. But I think because of the breadth of the territory it covers, there's going to be a lot of further discussion, not just by us, but by lots of people. And I think particularly now that, as Myles says, the starting gun has been fired on jurisdiction over global FRAND licenses. And the Supreme Court, I think, it implicitly recognizes that other jurisdictions other countries might well have a similar jurisdiction. It remains to be seen how many people take up that invitation and start considering global FRAND portfolio licenses in the context of patent litigation elsewhere. So a fascinating judgment, one that I've certainly been waiting a long time for, not just in the context of this action, but probably the last 20 years. So a great pleasure to have the chance to talk to you about it this morning, and particularly with such very excellent co-commentators as Myles and Andy. So thank you all very much for listening. There will be more material on our website over time. And, we look forward to talking to many of you about this judgment over many years to come. Thanks very much indeed. And Myles and Andy, thanks to you.
Thanks, everyone.
Thanks, Pat. Thanks, everyone.
Bye, everybody.
Bye.